How does a will affect children's inheritance rights? Imagine leaving behind a plan that decides who gets what after you're gone. A will is exactly that, a legal document that guides how your estate is shared. It plays a big role in children's inheritance rights by setting clear rules. When you create a valid will, your estate is distributed based on your wishes, not just state laws. This means you can choose to include or exclude your children from inheriting. If a child is named in the will, they are entitled to the assets you specify. But if a child is not mentioned or is explicitly disinherited, they might receive nothing unless laws protect their rights. If there is no will, called dying intestate, then state laws step in to decide how the estate is divided. Usually, children are given a significant share of the estate in such cases. Some states have laws called forced heirship or mandatory inheritance laws. These laws protect children from being completely cut out by requiring a minimum share of the estate for them. So even if you try to disinherit a child in your will, these laws might override your wishes. When it comes to who qualifies as a child, biological children are automatically recognized as heirs. Adopted children generally have the same rights as biological children, both in wills and under law. Stepchildren usually do not have inheritance rights unless they are explicitly included in the will or legally adopted. Children born out of wedlock might have inheritance rights, but it can depend on the jurisdiction and whether paternity or maternity has been legally established. Parents can disinherit children through a will, but children may contest the will if they believe there was undue influence, fraud, or if the parent lacked mental capacity. In places without forced heirship laws, parents have broad freedom to exclude children from their estate. To avoid disputes, it's smart to clearly name all children you want to inherit and specify any exclusions. If you have minor children, your will should also address guardianship and how their inheritance will be managed until they reach adulthood. Estate planning can help clarify complex family situations, like blended families or children born out of wedlock, to prevent conflicts. During estate administration, children generally have the right to be notified when probate or trust proceedings start. They can request copies of the will or trust, object if they believe the document is invalid, or contest it if needed. Children also have the right to refuse their inheritance if they choose. Overall, a will shapes how children inherit by setting who gets what and how much. But laws in each state can also protect children from being completely disinherited. Making a clear, detailed estate plan helps ensure your wishes are followed while respecting legal protections for children.